process in that it was conducted in violation of the law, and therefore no prejudice is required in order to dismiss. So I'll break it down into those three categories that we believe justify dismissal independently, each of them, of the indictment. The first, Your Honor, the state has waived its challenges to the motion to dismiss we filed. The state did not cite a single case in its opposition brief. It did not cite a single legal authority in its opposition brief. It did not distinguish any of our legal authorities. And it didn't challenge the majority of our factual statements either. And even when it did purport to challenge the basis for our factual statements, it mischaracterized our position and argued against something we had not, in fact, even asserted. For example, the state argues that Mr. Baldwin asserted the grand jury process was too short, and therefore that is one ground for our dismissal. As you just heard Mr. Spiro explain, our argument was not that the process was too short. It was that if the state was going to conduct the grand jury process consistent with the law, present the evidence that we believe was required to be presented, instruct the grand jury properly as to its roles and responsibilities, then a day and a half would not be enough time to do that. And so that was not a basis for dismissal. That was one of many, many facts that, as we laid out in our brief, points toward the mindset, the motivation of the state in conducting this prosecution, which was directly relevant to bad faith, where the courts have defined bad faith as dishonesty in purpose, belief, or motivation. And so even where we made arguments about things that were mischaracterized and responded to in a different way, when the state actually did respond. And so ultimately, the state waived the challenge, and we cited a number of cases to demonstrate that. For example, we cited the Delta Automatic Systems case. That was a waiver case. Now, short summary, Your Honor, just so you can see how on point our cases are versus what the state cited in its supplemental brief. Delta Automatic Systems, plaintiffs filed a brief. They argued their claim was not time barred. It was in the limitations period. The defendant explains, well, no, your case is time barred because actually the limitations period started earlier. Plaintiff doesn't respond to that. What does the court do? The court says, if you don't respond in opposition to an argument, then you've waived it. Dismisses the plaintiff's claim on the merits. There was no discussion of wanting to hear the case on the merits, no discussion of liberally allowing parties to ignore responses. Period, full stop, dismiss the case on the merits. Same thing happened with respect to an argument in State versus Vaughn. The defendant argued that the court violated his due process rights because he was subject to prosecution for refusing a breathalyzer test when, in fact, the first breathalyzer test he took, he agreed to take. He said, you can't prosecute me for refusal when I gave one. Doesn't cite a legal authority to support that argument. Factually, it was true. Doesn't support one. What does the court say? You haven't cited a legal authority. We will not consider an argument that lacks citation to any legal authority. And when you do that, we assume no such authority exists. Period, full stop, rejects the argument. No discussion of liberally granting opportunities, etc. We cited the State versus Tafoya case. Same exact thing. Court explains, you, defendant, argued the jury instructions were insufficient, but you didn't cite any legal authority for that. Argument rejected. You don't cite legal authority. You don't oppose legal authority that's cited to you. You've waived it. And what does the state say? The state does not distinguish our cases. It doesn't challenge those principles. Instead, if Your Honor even considers the state's supplemental reply, which we don't think you should because the waiver cases do not allow that, but even if you did, Your Honor, and you looked at the cases the state cites, none of those cases are about waiver. They're about default judgments, which we know is a very different scenario from waiver. For example, in the Gangler versus Phelps case that the state cites, the plaintiff sued two defendants. The parties agreed that the defendant's time to answer would be extended. When they entered the order, however, it only applied to one of the defendants. It was an accident. One of the defendants, therefore, didn't respond on time. The plaintiff got a default judgment. What do we think happened? Of course, the court said, we vacate default judgments liberally, and everyone thought this was supposed to apply to both, and so we're not going to hold you responsible for not responding on time. Springer versus Herrera, same exact thing. Default judgment entered, and the court says we liberally vacate default judgments. Nothing about waiver. SunWest Bank versus Rodriguez, another case the court cites, or the state cites to the court. This is an interesting one, Your Honor. There, for a couple of reasons. There, the plaintiff sued two defendants, a husband and wife, who had been separated because they defaulted on a loan. The wife, or the ex-wife, comes into the court after a default judgment was entered and says, I didn't know this wouldn't be handled. My ex-husband has all the information about this. I thought he was going to answer the complaint. And therefore, this is excusable neglect. The court says, fine, we think that is excusable neglect, but ultimately we don't find your defense on the merits persuasive. And therefore, we're keeping the default judgment intact. And why is this interesting, Your Honor? Because when you look at these default judgment cases, even though they don't apply here, even though the waiver cases are the controlling cases, and we ask ourselves, even if we applied that standard, excusable neglect, would the state be able to meet it if that were the standard? Is the state's knowing and intentional failure to respond to any of our legal arguments, any of our cases, its failure to cite any cases of its own, excusable neglect? How about the state's failure to address any of our factual statements? Is that excusable neglect? No, it's not. This is not a case where the state failed to answer at all and said, oops, we missed a deadline by accident. Can we please file our brief now? Where in those circumstances, the court would look at law office failure and technical issues. That's not this case. This is a case where the state did respond, and they responded on time. And they made the response they made deliberately, knowingly, with a calculated strategy to disparage Mr. Baldwin, to disparage me personally, rather than deal with this case on the merits, knowing full well the risks of taking that approach. This would not be excusable neglect, even if we did have to prove it, which we don't. And the state also cites this People versus Davenport case. That was a Colorado case about civil forfeiture, where the defendant didn't show up in response to a civil forfeiture claim, got a default judgment and said against him and said, but that should be vacated. And when asked why, he said, because the statute says I can either file a response or appear in person. I filed a response. The court says, yeah, that's right. You did. You complied with the statute by filing the response. You forgot to pay the fee, but you can do that later under Colorado law. Therefore, the default judgment shouldn't have been entered in the first place. Those are the state's cases, Your Honor. None of them on point at all. The only one that has some language that, even if it were relevant, it's not, would actually support the entry of dismissal because of the state's waiver. And so the state waived these challenges. It was the state's decision to present its opposition as it did, the state's decision not to cite a legal case, the state's decision to do all of these things. And the state said, well, that wouldn't be fair. It wouldn't be fair. It wouldn't be fair to give them this opportunity, to have them take the approach they wanted, and then give them a redo. Let's talk about fairness for just a moment, Your Honor. Let's talk about what the courts say about fairness in the context of a grand jury proceeding. Herrera said we need to protect the target's fundamental fairness. Strict adherence to the rules is required. Ulibarri said that prosecutors must conduct themselves, as Mr. Spiro said, in a fair and impartial manner. Ulibarri said that it's the target's right to a fair and lawful process that should be rigorously protected. That's what fairness is about in these circumstances. It's fairness to the target. And the only unfair outcome here on waiver would be not to apply waiver cases and not to dismiss this indictment on the basis of those controlling cases when the state brought this circumstance on itself by choosing the response it made. That's ground number one, Your Honor, on which we believe the court should dismiss the indictment. Ground number 2 and 3, as I mentioned, bad faith and judicial review of the evidence, and then the structural defects in the process. I'm going to start with the structural defects in the process, the violation of the grand jury process. Under New Mexico law, that is a basis for dismissal without proving prejudice. Once again, the state doesn't cite any cases about this ground for dismissal. In the state's supplemental reply, they say we've misrepresented the fact that bad faith is not required. It's very clear, Your Honor, we put it in our brief that bad faith is required on the third ground I'll talk about, but it's not required on this second ground. The courts have made that clear in New Mexico. Herrera said, for example, when we're talking about a violation of the grand jury process, a different standard applies to the target's claim, different standard from bad faith. It's quoting directly from the Herrera case. And the reason is that the grand jury process is one where the prosecutor has the control. There's no direct supervision of the judge, as Herrera noted. The prosecutor has the control of the room, the control of the witnesses, and ultimately has to rigorously follow the grand jury process to ensure that the grand jury has all the evidence before it so it can comply with its obligation to receive and evaluate all of the exculpatory evidence, all of the evidence that may make an indictment less justified. And so in the Herrera case, I want to start there, Your Honor, because in the Herrera case, there were two grounds for dismissal, independent. One was that the prosecutor asked the witness a question and the prosecutor didn't let that witness answer it. And the court said, ultimately, if the prosecutor had questions about whether the grand jury should hear that information, should have its questions answered by that witness, then the prosecutor should have gone to the judge. And the second was, and we see a lot of that here, Your Honor, as we've explained in our briefs. The second is that the prosecutor read proper UJI instructions to the grand jury, but then commented on one of them in a way that was consistent with the instruction, but sort of expounded upon it a bit. And the court said, no, we have to comply rigorously. We have to read those instructions exactly as they are, word for word. We cannot manipulate, we cannot change, we cannot modify. It is critical that the instructions are exactly what they need to be. And they weren't, and that failure also provided a separate ground for dismissal. And so let's start here, Your Honor, with the three reasons we give on this ground, independent again, for dismissing the indictment on the basis that it violated the grand jury process. The first is that the jury instruction was inaccurate. The first element of the jury instruction that the state read was that probable cause exists if the grand jury finds that the target discharged a firearm during the production of the movie without first verifying the firearm contained no live ammunition and while the firearm was pointed in the direction of another. The state then had a witness testify that Baldwin had an obligation to verify the firearm contained no live ammunition. Two pieces of this, Your Honor. The most troubling to us, the instruction is not correct. Judge Ellington heard argument on what this instruction should say, and we put our position forward, said it should reference Baldwin's subjective knowledge, which we do think is the law in New Mexico. And the state said, this is not about whether Mr. Baldwin should have verified whether the firearm contained live ammunition. There are other grounds completely distinct from that serve as the basis for this indictment. And Judge Ellington accepted that argument, that representation, that that's not what this case was going to be about. Shocked we were when we see the grand jury instruction inserting this exact language that the state had just argued was not going to be the basis for its case. Again, the grand jury judge was there for guidance. If the prosecutor had concerns about whether this language could be added in, that's what the judge was there for. That's what Herrera said the prosecutor should have done when deciding to cut off the witness. So that's troubling, Your Honor. What's even more troubling to us is that the state called Brian Carpenter to testify in the grand jury. And Brian Carpenter testified that it was Mr. Baldwin's responsibility to check the firearm. It was Mr. Baldwin's responsibility to verify the ammunition, and the gun was not live ammunition. It was instead a dummy or a blank. And that was definitive. They also had Detective Hancock say that the actor had to do the safety checks. 2 weeks later, Your Honor heard testimony in the Gutierrez-Reed trial that was exactly the opposite of that. We've quoted that testimony in the brief, Your Honor. Mr. Carpenter said, actors sometimes view the safety checks, but that's for a warm and fuzzy feeling, and that's rare. He said, sometimes actors say, nah, his words, nah, I don't want to check the gun. And that's okay, as long as you've checked it with the other sources, the other people who are responsible for checking it, not the actor. It's the armor's responsibility for verifying whether the gun has live ammunition in it or not. And you heard Ms. Morrissey in closing argument say the armor's the autonomous decision maker. The actor is going to manipulate the gun. Of course he is. That's foreseeable. Your Honor, we do not think, A, as an officer of the court, a lawyer can elicit testimony from a witness on these grounds saying X, and then 2 weeks later procure a guilty verdict in a related case by having that witness testify not X. We do not think, as an officer of the court, a lawyer should be able to argue one theory to the grand jury and then in a related case turn around and argue an opposite theory to obtain a guilty verdict. Just as an officer of the court, at a minimum. But to push it even further into the context of the grand jury process, all these cases, Herrera, the grand jury statutes, they all say the prosecutor is there, and as Mr. Spiro explained, there not to be the grand jury, but to aid the grand jury, to ensure a fair and impartial process, to ensure the grand jury hears the evidence that's contradictory. Lampman said, for example, if you put a prosecutorial witness up, a state witness, and that witness has information that's contradicted by another, you have to call the other. Lampman dismissed on those grounds. That didn't happen here, Your Honor. Exactly the worst scenario happened here. The same expert says X. 2 weeks later, the state has that expert say not X. That is not fair and impartial, Your Honor. That is not the presentation of contradictory evidence. It's exactly the opposite of that. That's number one, Your Honor. Related to this instruction, the premise of it, the history in front of Judge Ellington, and Your Honor has those orders and has that briefing. Number two, again, under the violation of the structural rules, the process, the state failed to advise the grand jury of its proper authority and role and failed to correct the grand jury's inaccurate view or misunderstanding of its authority in these circumstances. The rules are simple. Grand jury is required to obtain exculpatory evidence. The word under 31.6.11b is shall obtain, not may or might. And the prosecutor has an obligation to facilitate the grand jury's inquiry into that evidence. And again, facilitate is the word the courts use to describe this obligation, even above and beyond what the prosecutor decides to present. The prosecutor is there to be the aid to the grand jury, to ensure that the grand jury understands its role, its responsibilities. The state did exactly the opposite again. The state told the grand jury who the witnesses will be, not might be, not maybe, not the witnesses that the state intends to call, who the witnesses will be. And then the state reinforced this message by saying that the grand jury could consider the alert letter or just begin hearing witness testimony without explaining the third option. Consider the alert letter, hear the state's witnesses, and, as Mr. Spiro explained, call the alibi witness out in the hallway and look at the movie ticket. That third option was never explained, number one. And number two, it's clear the grand jury had no idea that was an option at all. Because when the grand jury was asked, how do you want to proceed? They said, well, I guess if that's all our questions about this letter, and the question they asked, Your Honor, was about a typo, they said, I guess we'll begin hearing witnesses. In other words, the witnesses the state told them definitively they were going to hear from. And so the whole exchange in the grand jury transcript demonstrates that the grand jury did not understand the purpose of the alert letter, its obligations and responsibilities, and the state didn't correct them. The state never explained Baldwin's witnesses were available to testify. In fact, they weren't. Mom wasn't in the hallway. Even though Judge Ellington told the state, you need to arrange for the scheduling to make them available, the state didn't even call them, didn't contact them. They never intended to call these witnesses. We gave multiple examples, Your Honor, of briefing in our briefing where the grand jurors were asking for information that would have been answered by the SAG statement, by Dave Halls, by Sarah Zachary, the industry safety guidelines, Joel Souza, or any number of other sources. Instead, when the grand jury asked those questions, the state cut them off, exactly the kind of behavior in Herrera that justified the dismissal on this ground, presented testimony from a different witness, and oftentimes testimony that contradicted what a different witness would have said. Carpenter's the best example. Or Adigio. Adigio suing Mr. Baldwin, seeking money damages. And Ms. Morrissey put some footage on a screen for Adigio to explain. And as we've all seen, intervening cause is a material issue here. Judge Ellington required the instruction to be read if there was evidence to support it. The state read it. And so Mr. Adigio is testifying about the footage that the state had put on the screen. And he says, well, there are a number of things that I'm concerned about here. First of all, as soon as Mr. Baldwin emptied the firearm and we had to reload it, Dave Hall should have called cut to give everybody the moment to safely reset. It appears as though, he continues, the armor is putting spent ammo in the same fanny pack or pouch as live ammo as she's pulling live ammo out of it. You kind of went past this for a moment, Adigio says to Ms. Morrissey. Dave Halls, the first AD who is in blue jeans and a black shirt, is not. Ms. Morrissey cuts him off. He's explaining intervening cause. I couldn't have dreamed of better testimony to start to explain intervening cause. Ms. Morrissey cuts him off in the middle of it. And after she had already taken something off the screen that he was trying to explain, and she says to him, and keep in mind, we're here for Mr. Baldwin. Point your narrative. What is Mr. Baldwin doing in this scene that we watched and anything that happened after when the camera turns off? Because we're not there. That's concerning you. That's exactly the kind of conduct, cutting off a witness, withholding evidence a witness is about to give. That ground alone in Herrera was a basis for dismissal, independent of anything else, that one thing. And that's because the whole point of the grand jury process, as Judge Ellington explained it in some of his orders, to give the grand jury more, not less. This is exactly giving the grand jury less on a critical issue of intervening cause. And then as we explain in our brief, Your Honor, there are examples of where the grand jury misunderstood evidence and said, Mr. Baldwin refused to check the gun. And then he got the gun. How would he check it? Would he shake the bullets? Would he put them in his hand? A question that has no premise in the evidence and is not accurate. Instead of correcting that misunderstanding, instead of having a witness who could explain Mr. Carpenter, as he did in the Gutierrez trial, saying the actor has no responsibility, she cuts it off. She calls Mr. Carpenter, who testifies exactly the opposite of what he testified under oath in front of Your Honor in the Gutierrez-Reed trial. Mr. Baldwin was responsible for checking the firearm and verifying whether it had bullets. Exactly the opposite. These are things that Herrera dismissed the indictment for. And when you look at the grand jury record, that first point I made about the grand jury's understanding of its role and responsibility, there's literally nothing in the grand jury record, nothing in the transcript to show that the grand jury was informed of its obligations and responsibilities. The state says, well, that's the court's responsibility. Judge Ellington should have done that. Well, there's nothing in the record to show what they learned, what they received. and how they were told about their responsibilities. The state didn't do it, and the state didn't correct it when it was clear they didn't understand. And the Ulibarri case, Your Honor, dismissed for exactly this kind of reason. In Ulibarri, the state argued that the grand jury was given a grand jury instruction manual, apparently from the description of a big pile of information that had all the things the grand jury could ever want to know about: its responsibilities, its roles, all the different kinds of crimes that exist, the elements of the crimes, everything you'd want to do to instruct a grand jury about how to be a proper grand jury was in that manual. But the state, when it came time to read the jury instructions in the Ulibarri case, just referred the grand jury to the manual and showed them how to use it and said, go there, and that's where you'll find the instructions. The court dismissed the indictment on this ground. Didn't have to prove prejudice, didn't have to prove materiality, because that violated the process. Why did it violate the process? Because the court explained in Ulibarri, it's the prosecutor's obligation to act in a fair and impartial manner. It's there to ensure that the grand jury received all the information it was supposed to receive. And the grand jury was supposed to be aided by the prosecutor in doing that. And there was nothing on the record, even though the prosecutor said that they gave the grand jury this manual, and even though the grand jury was supposedly told how to use it, there was nothing in the grand jury transcript that gives us or gave that court confidence that the grand jury had been properly instructed. Nothing in the transcript. And the court said that alone requires dismissal. If you can't, in the four corners of the transcript, find those instructions and have confidence in this indictment that the grand jury knew its role and responsibilities, then that's the end. Dismissal. No materiality required, no proof of prejudice, no proof of bad faith. In the State versus Hill case, we talk about grand jury secrecy. We read in the New York Times when the grand jury date would appear. The New York Times reported that Ms. Morrissey had conducted an interview, explained that the grand jury would take place on November 16th, and there was a lot of other comments about the firearm and the trigger, things that the prosecutorial rules of ethics don't allow prosecutors to say. Focusing particularly on the grand jury date, but also the rest of it, but on the date, if we look at State versus Hill, State versus Hill had a special prosecutor involved, and that special prosecutor had not been properly appointed. Therefore, when the special prosecutor was in the room of the grand jury presentation, there was an unauthorized person in the room. The court said, end of story, indictment dismissed. Why? Because the grand jury rules need to be enforced rigorously. Secrecy is a vital requisite of grand jury procedure. Quote unquote, State versus Hill. The fact that there was an unauthorized person in that room meant that the secrecy rule had been violated. Highly, highly technical. No proof of materiality. No proof of prejudice. Didn't matter. We safeguard the system. Secrecy is a vital requisite. The state disclosed the grand jury date to the New York Times in an interview. We've cited the article. That breached the secrecy rules. So did a number of other comments. You have all the briefing in front of you related to that. That alone, as Judge Ellington said, could cause significant prejudice, which we don't have to prove anyway. But Judge Ellington said, I am deeply troubled. The world knows this grand jury date. I don't want to read the New York Times tomorrow about anything that's happened here. Clearly, he had read the New York Times before and saw that interview. Because there are members of the grand jury coming to me, at least one, coming to the clerk and saying, I want to sit on the Alec Baldwin grand jury. That's entirely unacceptable, highly prejudicial. That's exactly what State versus Hill was getting at. You violate the secrecy rule, which that interview did by disclosing that date to the New York Times. That's the end. Rigorously and strictly enforce the rules. And this whole process, Your Honor, violated the rules from start to finish. The secrecy rules, the court ordered that witnesses be available. They weren't made available. They were not called. They were not scheduled. The state went on multiple media shows and made statements that violated the grand jury secrecy rules in violation of the ethical rules as well, governing the statements that prosecutors can make. which Judge Ellington expressly called out, as I mentioned. And we actually learned just this week, Your Honor, that the state paid Brian Carpenter to go on multiple TV shows, including the Sean Hannity show, to disparage Mr. Baldwin, make comments about his ultimate guilt, saying he pulled the trigger, had a duty of care, saying the prosecution was doing an excellent job, not disclosing he was a paid expert, being paid to go on a TV show to disparage Baldwin by the state. And so that's the second ground, Your Honor, for dismissal. No prejudice required. The third ground is that the prosecution acted in bad faith, which allows the court to review sufficiency, and the judicial review of the indictment and the evidence demonstrates that it should be dismissed. Now, number one, the state, again, cited no cases on this other than saying bad faith is required. On this standard, we agree with that. That's not the standard for the second ground. It is for this one. If you look at bad faith, Your Honor, bad faith is defined very broadly. It's dishonesty of purpose, belief, or motive. And we've cited numerous examples. I won't belabor the court today. It's all in our briefing, pages 36 to 38, for example, of our opening brief. Several examples of dishonest belief, purpose, or motive. Things like granting the 48-hour deadline to Gutierrez-Reed, and on the same day saying to Alec Baldwin, you're not going to get that 48-hour deadline, even though we've never seen this done before. Those are the sorts of things that in the aggregate and individually are sufficient to show a motive, a purpose, a belief that we believe opens the indictment to judicial review. So does Carpenter's testimony. Having a witness testify one thing in one trial and then the opposite in one presentation and the opposite in another shows dishonesty in purpose, belief, or motivation. Your Honor has all that. I won't belabor it. When you look at the evidence and do a judicial review of sufficiency, it's important to look at a few different examples. Again, I won't belabor the point. It's all in our briefs. But I want to highlight two things. The state called Detective Hancock. The state called Detective Hancock, and at the same time, she was on Mr. Baldwin's list of witnesses that we submitted to Judge Ellington and believe should be called to testify in front of the grand jury. Judge Ellington said, if you call any of these witnesses to the state, you're not required to ask word by word the questions that Mr. Baldwin put in his attachment to the alert letter, but you are required to elicit the information from those witnesses that Mr. Baldwin is intending to elicit so the grand jury can hear it. When you look at Detective Hancock's testimony, Your Honor, what you'll see is that Detective Hancock gave very tight testimony under very tight questioning from the state. She said Mr. Baldwin was required to do the safety checks of the gun, even though Detective Hancock had been specifically told by certain witnesses that he wasn't required to do that. She testified that the investigation was perfectly proper, the crime scene was secured, etc., even though there was specific evidence in the state's files from Chilling, for example, that it wasn't. She was asked a number of questions, very tightrope, that did not elicit the information that Mr. Baldwin argued should be elicited, and Judge Ellington approved that. So if you look at that testimony alone, Your Honor, you will see a violation of the requirements of Judge Ellington's order and New Mexico law. The state put Carpenter on the stand. You've heard the contrast as I've described it. The case law is very clear, Your Honor, that when you put a witness on the stand, a state witness, and that witness, a law enforcement witness, a law enforcement expert, gives testimony, you're required to put on testimony that contradicts it. The state doesn't do that. We've put all this evidence in our brief, Your Honor. Your Honor has the grand jury alert letter with that, so I won't go through it all. But the bottom line is that the list of evidence that the state had in its possession did not elicit and should have elicited is significant. Its own gun expert testified the FBI broke the gun. No signs of modification. Admits in the Gutierrez-Reed trial that the firearm shows evidence of rough tool marks on the hammer. We could go on and on, Your Honor. The point is there's significant evidence that was not presented to this grand jury that should have been elicited from Detective Hancock, that should have been elicited to Carpenter, that contradicted the evidence the state had presented at the Gutierrez-Reed trial, that upon review in the aggregate, we believe is more than adequate to show this indictment should be dismissed when you conduct a review of sufficiency. And so those are the three grounds, Your Honor. I'll stop and ask if you have any questions, but otherwise, our briefs detail this extensively, so I'll rest there.
All right, thank you. I'm going to basically take a bathroom break, and we'll get back on here. So it's 10:47. Let's return at 10:55, okay?
Thank you, Your Honor.
Okay, we're back on. Okay, so I don't have questions from your presentation at this point. However, I will later when the state finishes their response. Okay, and interchange. Okay, go ahead. Were you finished, Mr. Nikas?
I am. Thank you, Your Honor.
All right, thank you. Go ahead, Ms. Morrissey.
Your Honor, thank you. So I want to begin by briefly addressing the initial comments by Mr. Spiro. Mr. Spiro seems to think that there's something wrong with the fact that the case was dismissed and brought back. There's absolutely nothing wrong with that. That was an independent decision made by the special prosecutors because Mr. Nikas asked us to do that. That is exactly what happened. And his ask was not unreasonable. We did it because Mr. Nikas came to us and said, hey, it doesn't seem fair that this case continue to hang over my client's head while you guys are waiting for forensic testing that could be dispositive. So would you do the right thing and dismiss it without prejudice? We agreed to do that. So any complaints that the case was dismissed and brought back are an absolute misrepresentation of the history of this case. The issue with regard to the removal of the 48-hour language in the target notice, I've never fully understood what the concern here is. This isn't something nefarious. This is something that the state did because we intended to ask the court for a scheduling order under 5302.2, subsection D, which has since been removed from that rule. But it certainly was in the rule at the time that we were dealing with this because it struck us that this case was going to require that the court have enough time to consider all of the legal issues, and 48 hours was not enough time. Keeping in mind that we served Mr. Baldwin with his target notice approximately 3 weeks before the grand jury date. So we had created a situation where there was going to be plenty of time because the rule contemplates 10 days. The rule contemplates that the defendant receive his target notice 10 business days before the presentation. We gave it to him 3 weeks in advance. We asked the court for a scheduling order. Under the rule that allowed us to do it, the court declined. We understand that. We never asked the court to give Mr. Baldwin any less than 10 days, which is what the rule contemplated. There's no problem with that. If we had included the 48-hour language in the target notice and then filed a motion to modify it, the complaint would have been that they relied on the 48-hour notice in the target letter. So we removed it, told them we removed it, told them why we removed it. There's nothing nefarious about that. You know, we asked the court to permit a minimal voir dire of the grand jury because of the tremendous amount of press coverage that the case had received. We were open to having a conversation with defense counsel to see if we could come to an agreement about, just like somewhere between 5 and 10 questions to make sure that we had grand jurors who weren't prejudiced against either side based on all of the press coverage that they've seen. The defense didn't really object to that. What the defense did was they filed a motion saying, we want to ask these 100 questions. I mean, they wanted to do a voir dire that would have been a trial voir dire. And at that point in time, it was clear that we weren't going to be able to work together in order to craft a few questions to make sure that all the grand jurors were good to go. The court denied our motion. We didn't do it. There's no prejudice there. There's no problem with any of that. We asked the court to let us do something. The court said no. We respected the court's ruling. That's not evidence that a fix was in. It's not evidence that there was anything nefarious going on. Mr. Nickus has continued to, and Mr. Spiro supported it today, he has continued to indicate that there was a statement that they claim to be attributed to me that came out, I think, on the Today Show. That statement has never been attributed to me. Mr. Nickus has just continued to cite to a Today Show or an NBC News story and say that for some reason he thinks that I was the source that provided the information. He's never demonstrated that that was me. I don't think in my entire life I've ever used the phrase teaching moment. I don't think I've ever even said that in my entire life. So when we filed our response to the motion to dismiss the grand jury, quite frankly, I didn't have a lot of disagreement with the controlling case law. I don't disagree that Herrera is a case that should be reviewed by the court. I don't disagree that Jones is the controlling case, both of which are actually cited in my brief. I referred to Judge Ellington's order citing Herrera and Jones. So when Mr. Nickus tells the court this morning, we didn't cite to a single case, that's not true. We talked about Herrera. We talked about Jones. We've given the court a little bit more information in our request for supplemental briefing with regard to Herrera. We cited to 31-6-11A. We cited to UJI 14-231. That is the controlling law on this issue. We discussed it. We cited it. Where we disagree with the defense is on the facts as they have presented them to the court. So as a threshold issue, the court has to find that there is bad faith on the part of the prosecution before conducting a review of the grand jury. In support of bad faith, the defense seems to rely on the Herrera case, but I don't think the Herrera case is... Hang on, let me get to... In terms of bad faith, the Herrera case found bad faith on the part of a prosecuting attorney. But in that case, the prosecuting attorney ordered the target, not to answer a direct, relevant question from a grand juror. That is not at all what happened during this grand jury. The attorney also, in that case, told the grand jury that the target's testimony should not be considered because it was an impermissible attempt to make the grand jury consider the consequences of its decision to indict. That is not what happened in this case. I agree that Herrera should be reviewed by this court. But the facts, as presented, don't support a dismissal of the indictment based on Herrera. Herrera is completely distinguishable, and Herrera was cited in our brief. In the Baldwin grand jury, we had witnesses who were not at all familiar with how safety protocols work on movie sets, because hardly anyone knows how safety protocols work on movie sets. Detective Hancock, a grand juror posed a question to Detective Hancock about the specifics of how safety protocols work on movie sets. I decided to have another witness who actually understands how those safety protocols work answer the question. I didn't hide any information from the grand jury. I certainly, when I did that, my intention, since we're talking about bad faith, was to ensure that the grand jury got information that was accurate and reliable. And they were going to get accurate and reliable information from the guy who's an expert in movie set safety, not from a Santa Fe County Sheriff's detective who doesn't know anything about set safety on movie sets. That's not an example of bad faith. Mr. Nikas has tried to convince the court that somehow there's something wrong with Mr. Carpenter's testimony, and that his testimony before the grand jury in this case is somehow supportive of a nefarious intention on the part of the prosecution. I have reviewed Mr. Carpenter's testimony from the trial. I have reviewed Mr. Carpenter's testimony from the grand jury. Carpenter's testimony in the Gutierrez trial is that the armorer is in charge of gun safety. We agree. He also testified to that before the grand jury. Mr. Carpenter's testimony in the grand jury was that the actor has responsibility for the firearm once it is in his hand. That is absolutely accurate. I have gone through and pointed the court numerous times to the safety protocols for movie sets. And what they say is, the person who's holding the gun isn't supposed to point it at anyone. The person who's holding the gun is supposed to keep their finger off the trigger. The person who's holding the gun is supposed to know what their intended target is. All of those are things that Mr. Baldwin failed to do, and that information was appropriately presented to the grand jury in this case through the testimony of Mr. Carpenter. The defense wants somehow to try to convince the court that the actor who is holding a real gun in his hand has absolutely no responsibility for what he does with that gun. And it's simply not the case. And it's not the case when you look at Mr. Baldwin's own guidelines from the Screen Actors Guild. So we're presenting the evidence that we have that supports the charge. In addition to doing that, we presented this grand jury with lots and lots of exculpatory information about Ms. Gutierrez's failure, about the source of the live rounds. That is the proximate cause. The proximate cause issue that the grand jury absolutely needed to hear about and understand is Ms. Gutierrez put a live round in the gun. And Mr. Baldwin didn't know that there was a live round in the gun. That's proximate cause. And that was presented to the grand jury because I agree, it's exculpatory. It goes directly to the proximate cause jury instructions that they didn't have to argue with us about. We gladly presented those jury instructions to the grand jury. And I can't imagine a world at trial where we're going to object to those. There's not bad faith here. There was no testimony at any point in time, not in the grand jury, not at the Gutierrez trial, that the actor is required to participate in the safety check with the armorer and the assistant director. Nobody ever said that. It's not true. It's his option, and he declined to take advantage of it. We are presenting the facts to the grand jury as we see them. With regard to Mr. Nickus in his motion goes through this series of bullet points that he believes are related to bad faith. And one of those that has been discussed today, probably the only one that's actually relevant to the grand jury, is the information or the rather the interview. I wouldn't call it an interview, but I did provide the New York Times with the date of the grand jury. I've acknowledged that. I've never tried to hide that. Honestly, I absolutely understand that grand jury proceedings are secret, but the date of the grand jury, this isn't a federal grand jury. The date of the grand jury proceeding is given to witnesses who do not have an obligation to keep it secret. They don't sign an oath. They have no obligation to keep that secret. It is given to the target. The target can give it to his wife. He can give it to his parents. He can give it to his wife's hairdresser. He can give it to whoever he wants. The date of the proceeding, in my opinion, is not secret. But best case scenario for Mr. Baldwin, let's say it absolutely is. The date specifically is something that nobody's ever supposed to know about, even though we give it to a whole bunch of people. The grand jury didn't happen on November 16th. The judge moved it. He moved it because he needed more time to address the legal issues, and that was the reason that we asked for a scheduling order in the first place. So the grand jury was moved from the 16th. Mr. Nickus has continued to try to argue in his pleadings, although he hasn't seemed to argue it much this morning, but he seems to argue in his pleadings that after that, I again provided the grand jury date to the press. Absolutely not. That absolutely did not happen. So, and I can tell you, Judge, it wasn't bad faith. It was just my understanding of the fact that everybody ends up with the date. A bunch of people who are not required to keep it secret get the date. And if that was a mistake, it's my mistake, and I'll take responsibility for it. In terms of the waiver issue, all of the cases cited by Mr. Nickus are civil cases. But again, they presented the case law that we agree is the controlling case law. We simply disagree with their recitation of the facts. So I filed a response that was largely my recitation of the facts. I do want to say with regard to Herrera, paragraph 20, our grand jury statutes require that the prosecuting attorney alert the grand jury to the existence of target offered evidence and do not require the prosecutor to actually present such evidence. Once alerted to target offered evidence, the grand jury remains free to decide not to hear the evidence or to hear the evidence and weigh it as it sees fit. So despite that is the law in the state of New Mexico, the defense continues to argue to this court that our failure to, one, notify the grand jury of their obligation or not their obligation, but notify the grand jury of their power to call witnesses and review documents was somehow inappropriate. And in addition to that, the argument that we didn't call their witnesses, we didn't present the testimony that they wanted us to present. We are not required to do that. We went above and beyond in this grand jury proceeding, providing to the grand jury, not only did I read the target letter in its entirety, word for word, I gave each and every grand juror a copy of it. They had it the entire time we were going through the presentation. We didn't take those copies back. We left those copies with the grand jury the entire time, so that if at any point in time they wanted to reconsider and they wanted to say, hey, we'd like to hear from so-and-so, they had it with them the entire time. What I've always been a little mystified, other than reading the entire target notice and giving each and every grand juror a copy of it to read, asking if they want to take a break to consider it, giving them time to consider it, waiting for them to knock on the door, coming back into the room and saying, how do you want to proceed now that you've had time to review the target notice? And them saying, let's proceed with the witnesses you have. What, other than that, what am I supposed to do? And in this regard, if the court will indulge me, to a certain degree, the defense has misconstrued what Judge Ellington ordered when we had our hearing on January the 11th, 2024, prior to the grand jury. I would like to play just 5 minutes, a 5-minute audio of that hearing, so the court can understand exactly what Judge Ellington ordered and the back and forth that we engaged in. Would the court indulge me 5 minutes?
Mr. Nikas, Mr. Spiro, what's your position? Spiro, I'm sorry.
Yeah, I would object unless we're putting in the whole transcript, and she can submit it to the court in camera. I don't think we have to sit here and see some snippet of it, and then I have to do redirect. I would ask that the court just review it in camera if the court thinks it's necessary. I know the court has the transcript.
And I would also add, Your Honor, that none of this was presented in the context of the opposition brief, so the request for full context, the full transcript argument on this would be highly prejudicial if it were going to be this focused and narrow.
I'm aware of the I've certainly read the log notes and listened to the log notes of Judge Ellington's order. So make your point, Ms. Morrissey. I don't need to be refreshed. Thank you.
So the point is, Judge Ellington asked the grand jury clerk to provide refreshed copies of the grand jury orientation instructions so that the grand jurors, even though they had already had all of that information in November, even though they already understood that they could call witnesses, that they could subpoena documents, Judge Ellington had the grand jury clerk give them those instructions again so that they would be refreshed about what they can do in the grand jury, the powers that they have, the witnesses that they can call. There is no obligation on my part to start explaining to the grand jury something different than what the court has already provided them. They were provided those as a refreshment. And that explained everything that they could do. They understood their powers. I had a discussion with Judge Ellington about the fact that obviously, because this decision is coming, I think, less than a week before we're presenting the grand jury, that there would be some witnesses that we wouldn't be able to get there. We weren't going to be able to get out-of-state witnesses there. I had this entire discussion with Judge Ellington because I had concerns about it. And I asked the judge, if they want to hear from a witness and I can't get them there by the time the term ends, what's the best thing for me to do? Are we going to ask the grand jury to stay together, to come back on another day? Judge Ellington said that's a possibility. If any of these problems arise, I will be in the courthouse because I'm going to be in trial. Just come and speak to my staff. And if I need to render assistance, I'll render assistance. The grand jury never asked to hear from the witnesses. There's nothing I can do about that. Again, Judge, if the court wants to buy Mr. Nickas's argument that is predicated on a bunch of civil cases with regard to waiver, that's okay. We can just focus on the cases that the defense presented because those are the controlling cases, and that is the controlling statute. We did everything that we were supposed to do. We went above and beyond, and I want the court to understand at the conclusion of evidence, I reminded the grand jury that if there were any documents in Mr. Baldwin's target letter that they wanted to see, I had copies of them right there. And when I said it, I pointed to 3 bankers' boxes that were sitting behind me. They were sitting there in the room and I pointed to them because I had copies of each and every document for all of the grand jurors, and I think there were like 22 grand jurors in the room. So not only did I tell them, knock on the door and let me know if you want to see any, I made very clear to them that they were there and that they would all have copies of them if they needed them. This is not a trial. This is grand jury. They provided an alert letter. We read it. We followed all of the judge's orders. If the court has any questions for me, I'm happy to answer them.
I'm going to let you do your reply.
So, Your Honor, just very briefly, and then I'll turn it back over to Mr. Nikas because a couple of the points directly related to his points. But the colloquy with Judge Ellington suggested that he understood the logistic problems. That's what being a prosecutor is like. Sometimes it's not easy. You want to have a case on the last day. You don't get to fast pitch it. There's lots of options, right? One option is to have the witnesses there, one of them there, one exhibit there, right? There's nothing in the transcript about pointing at some boxes of evidence. There's nothing like that there. And there aren't any witnesses there. So what Judge Ellington is saying is, hint, hint, you might want to be careful. I know I'm going to get a motion on this, and this is a runaway case, and there's a lot of zealousy going on. You could also delay the grand jury presentation so that you're not on the last day. There's lots of options to do it. Anybody who's a seasoned prosecutor knows that. And then the other point that I would just make is where Miss Morrissey started, which is, this wasn't nefarious, wicked, evil acts of horror. I never said that it was. I don't think this is some wicked, evil prosecutor or some horrible person. But on that day, in that grand jury, they didn't do what they should have done. It's just that simple. You're not supposed to do that when you're a prosecutor. You're not supposed to conduct yourself that way. And that's not an indictment that this court can hang their hat on.
I have just a few points, Your Honor. Our briefs address anything that the state has argued, most of what it's argued, in fact, has been waived in any event. But just a few points to illustrate some of the areas where the state has made comments that are not accurate, and ultimately we'll hang our hat on everything else we put in our brief to demonstrate that the rest of it is consistent with these. And so, number one, the state says we don't cite any criminal cases on waiver. We only cite civil cases. That's not accurate. We cite State versus Vaughn. The standard on waiver is exactly the same for both scenarios. Number two, the state says we didn't call Detective Hancock to talk about gun safety because she didn't know about gun safety. That's why we stopped her and we actually had somebody else testify. That's not accurate. Ms. Morrissey asked Detective Hancock about what happens when the armor hands the gun off to the actor. And Detective Hancock said she's supposed to do a safety check with the actor, and ultimately that wasn't done. So the testimony of Hancock, even though we just heard from the state, which is not knowledgeable about safety standards, the state elicited that. Number three, the Herrera case, Your Honor. The Herrera case does not say when a target is giving testimony and the target is saying a certain thing and the state cuts them off. The target, because the target has a right to be there, therefore has created a scenario where an indictment must be dismissed. The outcome of that case had nothing to do with the fact that it was the target testifying. The court made very clear that when a prosecutor cuts somebody off and denies the grand jury information that they've asked for, that period full stop is an interference with the process and denies them what they're entitled to. And if Your Honor looks through the transcript and sees the number of times the state said words like, let me stop you, or I'm going to stop you, or you're going to hear this information from somebody else. It's over 20 times. Day one, pages 20, 26, 27, 34, 88, 160. I could go on and on and on, Your Honor. This was something that happened. It was pervasive throughout the entirety of the process. And so if you look at the Herrera case and the basis for it, and you look at the cases we cite, we respectfully submit they require dismissal. And the state did not discuss and talk about and analyze these cases. The only reference the state made to any cases was when it said in Judge Ellington's order, where he cited Herrera and quoted Jones, Judge Ellington said such and such. There was no analysis of the case law. There were no cases cited for authorities. The state didn't address any of these issues in its brief. And so, Your Honor, we could go on and on, but Your Honor has questions. That's what's most important to us. And everything else that we've written in our brief, we believe is clear, and we simply refer to them.
All right, thank you. First of all, I want to ask Ms. Morrissey where she's relying in Jones and Herrera on the fact that they have to demonstrate bad faith before they can get into any of these arguments.
Yes, Your Honor. It is, hang on just one second. Give me just one moment.
Sure, take your time.
Paragraph 13, I believe, Your Honor. And in addition to paragraph 13, I would also rely on 31611A. The sufficiency of the evidence upon which an indictment is returned shall not be subject to review, absent a showing of bad faith on the part of the prosecuting attorney assisting the grand jury.
Okay, so I started off asking counsel to address the two types of errors. One is, which I'm quoting from Herrera, and that's paragraph 12, challenges arising from grand jury proceedings ordinarily fall into two categories. Challenges to the quality or sufficiency of the evidence before the grand jury, and structural challenges involving the manner in which the grand jury process has been conducted. If you finish the paragraph 13, it says, in accordance with the statute, our courts will not entertain a target's challenge to the quality or sufficiency of the evidence presented to the grand jury unless the target demonstrates prosecutorial bad faith. And your cite to 31611 also talks about the sufficiency of the evidence upon which an indictment is returned shall not be subject to review absent a showing of bad faith. That doesn't include structural. And Mr. Nikas addressed structural right after the waiver. And so I think that the fact that you're arguing that he has to show bad faith is incorrect on other than the sufficiency of the evidence. So I don't think that that was properly addressed by you. Now, I'm going to ask you some questions, and I'm going to ask you questions because you were the one doing the grand jury. So, I may ask Mr. Baldwin's counsel, but I'm primarily focused on what occurred at the grand jury. So one of my first questions is, and I'll try to stay. Let's go to the information about the lack of advisement about the target. The target, you saying that reading the target alert letter went above and beyond what you were required to do. And you gave some information about at the very end, you even reminded them of the boxes. And I'm just wondering why you wouldn't have reminded them of the witnesses as well at that time.
Well, the reason that I wouldn't have reminded them of the witnesses is because they had the target's alert letter in their hands the entire time. I know for a fact that they reviewed it, and you can see that from the transcript because they were actually asking about typos in it. So I understood that they had reviewed it. I understood from the hearing that we had on January the 11th that the clerk of the grand jury was providing them with a refreshed instruction that they had the power to request any of these witnesses. So it was my understanding from the hearing that we had on January 11th that they were being provided a refreshed instruction in that regard.
Okay, thank you. When you talk about, as we know, Judge Ellington said, make the witnesses readily available. And in your response, you said that you would have made them readily available had the grand jurors asked, and you said if they couldn't come in person, I'd ask the grand jury judge for permission to have them appear by video testimony. But then you also said, or I would have given them interviews of pretrial interviews or investigative interviews. How can a grand juror ask questions from a transcript?
I agree with you, Your Honor, and this was one of the things that was discussed during the hearing with Judge Ellington. I believe it was the same hearing on January 11th, was the fact that some of the witness testimony that Mr. Nickus wanted to present was directly from the interviews. So for example, what Mr. Nickus would do, and you can see in his notice and his alert letter, he provided to the court these exhibits that were summations of the police report. So for example, he provided the court with a copy of Detective Hancock's supplemental report that described her interview of Jensen Ackles. And so I had a discussion with the court about if what the defense is asking for, and they certainly were not asking for this for every single witness. So I didn't think that this was going to fly with every single witness. But if what they were asking for was this witness's testimony as it was given to Detective Hancock or Detective Cano, and we had those audio recordings, then we don't need to bring that person from California to have them talk about that in front of the grand jury. We discussed that with Judge Ellington, and he indicated, yes, that would be a possibility. So I do agree with the court that when presenting the testimony that way, if the grand jury had questions, they would be having to pose those questions to Detective Hancock as the person who did the interview. And I want the court to know that I actually spoke to other prosecutors, primarily in the 2nd Judicial District, to ask if they had ever presented witness testimony over video, Zoom or Google Meets, and they indicated that they do it all the time. So I had actually taken steps to ensure that I had a leg to stand on with regard to having witnesses testify via video, understanding grand jury secrecy, that one of the things that we would have to do if we did that, if Judge Ellington approved it, would have been having the witness under oath testify that they were alone and that they weren't recording, and et cetera, to try to ensure grand jury secrecy. So I was trying to come up with ways of presenting some of the testimony. Now, with regard to some of the witnesses, though, I was not at all opposed to having them there in person. The problem with the situation was we only had a week from January the 11th. We didn't know how Judge Ellington was going to rule. So on January the 11th, we get the ruling. And then at that point in time, I'm trying to figure out what to do with these out-of-state witnesses. It's true, I didn't have Sarah Zachary sitting in the hallway, but I could get her there, and I knew that I could get her there because I had talked to her attorneys on the phone about grand jury. So for the local witnesses, the witnesses that were local, that the defendant wanted the state to make available, I absolutely was intending to have them there in person. It was the out-of-state witnesses that I was trying to figure out how I could juggle those. So I was hoping that if the testimony was requested, we would be able to do it either from video interviews, understanding, Your Honor, that there may be an issue with regard to grand jury questions, or just having them present by video, which my understanding is in the second is routine. So that was my plan at the time.
I'm curious as to that you didn't reach out to any of these witnesses other than what you just said, Sarah Zachary, to just sort of touch base with them, see if they were available even by video.
I'm not I actually don't agree that I didn't reach out to them to see if they were available. I recall, I believe I had a conversation with Mr. Souza. I did not have a conversation with Mr. Halls, but that's because he was represented by counsel. And his attorney was historically very difficult to get a hold of. So I was going to have to try to manage that as best I could through Judge Ellington if the grand jury wanted to hear from Dave Halls. I don't think that it was just Sarah Zachary. I'd have to go back and look at all of the witnesses that the defense asked that we present, because I did make phone calls to kind of let people know that this may be an issue that would be coming up. I specifically spoke to Mr. Winger with regard to Ms. Zachary. Do you want me to go through the witnesses? I'll have to pull up their alert letter. I can go through each and every witness.
Well, you never responded that you did. That they said you didn't, and you didn't respond that you did. And there's 7 of them.
Sure.
I'm just asking. I mean, if you're saying that you did, I mean, I'm just curious as to. You're saying, well, I was trying to coordinate this, and I knew that Zachary I'd get and Hall's attorney is pretty difficult to get a hold of. Then I'm curious as to, even by video, how you would have how you needed to. Common sense tells me you should have reached out ahead of time. That's all.
Oh, I agree with you. And I'm telling you that I think with regard to Mr. Halls, I reached out to these people. But for this, let me look at specifically all of the witnesses and let me address the court's inquiry here. I have so many documents in front of me. I'm trying to find
Take your time.
I'm trying to find their alert letter. I had it in front of me. Here, I'm getting there. Okay, witness number one, Mr. Souza. Mr. Souza was extremely cooperative with me. He made himself available anytime I wanted to speak with him. I believe that I would have had absolutely no issue having Mr. Souza appear via video. The next witness number two, Mr. Halls, I've explained that. He's always difficult because we have to go through his attorney and she can sometimes be somewhat non-responsive. Ms. Zachary, witness number three, I've addressed that. Witness number four, Ryan Smith. I did not reach out to Ryan Smith. He, as a producer for Rust Productions, I believe that technically he is currently represented by Ryan Villa. Ryan Villa has been extremely cooperative with me, and I expected that if the grand jury wanted to hear from Ryan Smith, I would have been able to present his testimony through the cooperation of Mr. Villa. Detective Hancock was there. Of course, the grand jury was free to ask her any questions that they wanted that she could have had the answers to. Witness number six, Joel Cano, absolutely. He's with the Sheriff's Department. I could have had him there within 10 minutes. Mr. Schilling, I did not reach out to Mr. Schilling, but I absolutely had full confidence that if the grand jury wanted to hear from Mr. Schilling, although his testimony I can't imagine would have been highly relevant to them, I would have been able to get Mr. Schilling there. I think Mr. Schilling lives in Santa Fe. He would have been very, very easy for me to contact and have him there. He's retired and he is generally available. And I want the court to know that, one of the reasons that we read the target's alert letter at the beginning of the grand jury is so that if they say, okay, we've met and we've conferred, and we want to hear from these three witnesses, or we want to hear from all seven, then I can tell my investigator, while I'm presenting the witnesses that we have here, you got to go get these other guys. You got to call Mr. Winger and you got to tell him that Sarah Zachary needs to be here. And you need to go knock on Mr. Schilling's door if he doesn't answer his phone. So we would have had time to do those things. We knew that this grand jury was going to take quite a long time. I know that the defense has continued to argue that this was something that we rushed through. As this court knows, it's almost unheard of to have a day-and-a-half long grand jury proceeding. We didn't rush through anything. We spent a long time. We had every single grand juror come back the following day. In terms of, let's say, worst case scenario, the grand jury wants to hear from a witness that I can't get there. So I had a specific conversation with Judge Ellington. If that worst case scenario arises, what do we do? Do we ask the grand jury as a group to agree to come back at a later date? And he indicated that was a possibility. Now, the other possibility is that if the grand jury wants to hear from a target's witness, and for some reason we can't get them there, and this didn't happen, we can, if we choose to, start the process over. There's no way that we would have, if we had a grand jury that said, I want to hear from Dave Halls, and I can't get Dave Halls there for some reason, I'm not going to continue with this grand jury proceeding and just have them indict him and come to the court and say, I couldn't get a hold of Dave Halls. That's not how this works. We would have just had to have dismissed it, and we would have had to issue a new target notice and start over. And at that point in time, we would have had a much better idea about what the court's ruling was going to be. We didn't know the court's ruling until January 11th, but if we had to dismiss it and start over, which we absolutely were contemplating could be a possibility, we were willing to do that. We were never going to have a grand jury issue a ruling if they wanted to hear from a defense witness and we couldn't get that person there. Absolutely not.
Okay, I have one more question on with respect to the target letter. So as an aide to the grand jury, and I remember listening to the transcript, and you said, after you read the target letter, you said, we have witnesses available now, and you emphasized in your tone now. And then you stopped and told them, go ahead and read it among yourselves and things. Why would you not just at that time, you're telling me that you, in your response, you said it's not your duty. All you have to do is alert them. And then I asked you today and you're saying, well, they were told to the jurors, Judge Ellington instructed the jurors to get another copy of that, their duty, what's read to them about their duties. And then, and so that, I think that's, I don't want to misstate, but I think that's the sum total. So as an aide to the grand jury, I'm just curious as to when they were seeing typos, did you not feel as an aide that you might let them know that you could get them there? That's why I asked you about the boxes at the end, because you went to the boxes at the end. You said, we've got the boxes here, but you didn't mention the witnesses. And so I'm just curious as to, as an aide to the grand jury, why you just didn't, what would have been what was the motivation, or what would have been the harm in just not saying, and you know what, I can get them here if you need them, or something to that effect. Just make them a little more schooled in what they were. Do you stand by that it's not your duty, basically?
I stand by that it's not my duty because the law and the case law doesn't require me to do it, but I don't want the court to feel like there were things that we were unwilling to do because we were kind of engaging in some kind of gamesmanship, like if the law doesn't require me to do it, I'm not going to do it. My honest belief at the time was the judge has provided them today with the refreshed instructions about their duties. So I had no reason at that point in time to believe that they were confused about whether or not they could ask to hear from any of these witnesses. If Judge Ellington hadn't specifically asked that instruction be provided to the grand jurors again, because it was provided to them in orientation and he had them refreshed, possibly I would have handled it differently. But because he did that, I didn't believe that it was necessary.
Do you know whether they got that? You said that morning. Do you know whether they got that?
I was assuming that when Judge Ellington, and that was actually part of the audio that I wanted to play, when Judge Ellington instructed, I think he said Ms. Hurtado, I think that's Ruth, when he instructed her to provide those, I had every reason to believe that she was going to do that. She was on the call. So when we had the hearing on January the 11th, there were several court employees that were on the video hearing, and she was one of them. So the court specifically told her during the hearing, the court didn't say, this is what I'm going to do. He told her during the hearing, this is what you need to do. I assumed that she would have followed his instructions. I had no reason to believe that she wouldn't have done that.
Okay, I am aware of that. I did listen to that. I want to get into what was raised about asking the witnesses questions. In the beginning, you tell the grand jurors that this is how we're gonna do it. I'm gonna ask questions of the witnesses, and then you can ask questions, and I'm gonna interrupt and say you can't answer that question if I consider it to be not a lawful question, and I may have them rephrase the question. And so, got my notes here. So, having gone through the transcripts, I'm in Herrera and talking about how Herrera says, and so you're honing in on the target. You seem to be honing in on the target in Herrera in Herrera it says, by preventing the target from answering a direct relevant question from a grand juror, the prosecuting attorney interfered with the grand jury's statutory duty to make an independent inquiry into the evidence supporting a determination of probable cause. So I think you've said two things, and please correct me if I'm wrong, because I've been, taking notes, but I'm not a transcriber. So you talked about that it was the target in that case, and you seem to make a distinction between the appellate court saying that that they interfered because they wouldn't let the target answer the question. But then you also said that that you came well within Herrera, and so that you didn't interfere with their ability to ask questions. So I just need clarification. Are you interpreting Herrera to mean that the appellate court based it on the fact that the target was interrupted from answering the question versus another witness of the state?
Judge, the only thing that I can say is when we're looking at cases and we're distinguishing cases, looking at the facts of the case, that's what we look at to see if it's distinguishable. I don't know what the Court of Appeals would do if it wasn't the target. What I can tell you is that I think that depending on the substance of the testimony that's coming out, the Court of Appeals may handle it differently because the target has a right to testify. So I think that is a difference. The target has a legal right to testify. The target is the only person who has a legal right to testify before the grand jury. So I think it's entirely possible that the higher courts would treat that somewhat differently depending on what the substance of the testimony was. And again, it was my intention not to prevent the grand jury from getting the information. I just wanted the grand jury to get accurate information. And I had concerns that a police detective wasn't going to give accurate information about safety protocols for guns on movie sets because she's never worked on one. And I certainly would submit to the court that that's not bad faith. That's me trying to make sure that the grand jury doesn't get confused by getting inaccurate information.
Okay, so it did involve the target, but it said it's not the target. I don't think Herrera was focusing on the target's right. I think Herrera was focusing on the grand jury's ability to ask questions without interference. It says, by preventing so-and-so from answering a direct, relevant question from a grand juror, the prosecuting attorney interfered with the grand jury's statutory duty to make an independent inquiry into it. So I noticed that Corporal Hancock was able to answer several questions, and they were about the firearm. They were about She was able to ask questions about sorry. Okay. So they're asking questions like, they were talking about live rounds. They were all in different places. One was in the actual gun that was used, and Hancock says yes. There wasn't another one in the gun. Corporal Hancock answers that. And then they're talking about were you able to get all of them back? Yes. The gun was already unloaded when we got there. And then they're asking her questions, and you say, can I try to help, and you go along. But then the first time you interrupt a juror is with Corporal Hancock is when one of the jurors asks if the bottom line is the response, and it's a very direct question, and so you're going to tell me that she could not have answered this. And so the bottom line is the responsibility of making sure these bullets are not live, are up to what? David Halls and Hannah. And you did not let her answer that question. You said, we are going to have another witness address those issues for you. We have an expert who works on movie sets, and he's going to answer those questions for you if that's okay. And so my question is, she was the lead investigator on the case. Her testimony shows that she could have answered that question, and you would not let the grand juror get the question from Ms. Hancock. Why is that not what Herrera says you can't do?
So what Herrera, in my reading of Herrera and the way that it would apply to this case, is the grand jury was prevented from getting the answers to the questions. I did not prevent the grand jury from getting the answers to the questions. I made sure that the grand jury got the answers to their questions from the witness with the most experience. I want to back up because, Judge, what you indicated in terms of all of the questions that Detective Hancock did answer, those all pertain to her criminal investigation. Where the guns were, where the bullets were, did they recover all of them? Those all pertain to her criminal investigation. My concern was that Detective Hancock didn't understand, or perhaps didn't recall what she had been told because so much time had passed since the time that she did her interviews, the very specific way that the safety protocol takes place between the armorer and the assistant director. So I presented that information to the grand jury. I had their question answered, and my expert absolutely said, the safety check is a safety check that takes place between the armorer and the assistant director. He did not say that it took place with the actor in terms of that initial safety check. So I think that there is a very stark difference in what happened in Herrera and what happened in this case, especially when we're talking about bad faith, because my intention was to get them the most accurate and reliable information. And having a police detective who's never worked on a movie set try to give some kind of a detailed explanation about the exact manner in which this safety inspection is supposed to happen was concerning to me. And I also want the court to know that the reason that this death occurred is because the safety protocols were not followed. So during her investigation, what Detective Hancock learned was the way not to do things. Detective Hancock never talked to, I don't think Hancock ever interviewed any of the crew members and asked the experienced crew members how the safety protocols were supposed to work in a way that wasn't this distorted way that happened on this movie set. So it wasn't necessarily that I didn't want her to give the information. In fact, I can tell you it wasn't at all that I didn't want her to give the information to the grand jury. Detective Hancock got a bunch of information from people about the way not to do things. That's the reason that Halyna Hutchins died. So I actually didn't believe that she fully understood the way that things are supposed to happen, because the sheriff's department doesn't go hire an expert and get a teaching lesson in how these things are actually supposed to happen. She got her information about how things are supposed to happen from the three people who didn't follow the rules, that being Hannah Gutierrez, Dave Halls, and Mr. Baldwin. She didn't conduct any of the other interviews with the crew who would have been able to tell her, had they been asked, this is the way this is supposed to happen. So I had a good faith basis to believe that she only understood how it's not supposed to happen and didn't understand how it's actually supposed to happen.
Well, to that point, a couple of things. Well, first of all, Corporal Hancock interviewed Jason Ackles. And in that interview, he had different information about safety protocols on movie sets, which would that have been exculpatory information?
I'd have to review it. Do you want me to review it now? I'm happy to.
Okay, so here's, I'm just saying she did have some information, I think. But in any event, when you're saying, so you're saying she was not the best witness to answer that question, or she wasn't capable of answering that question given her limited, she didn't know what the best practices were. Is that correct?
That's correct.
Okay, well, so, but in other ones where you go, this is, I think this is Mr. Rice. Or is it, yeah, I think it's Mr. Rice. And you say on Exhibit 20, page 86, and it says, looking back at the alert letter, there's a notation that Sarah Zachary, the prop master for the film, was also the supervisor for Hannah Reed. But nobody's talking about her playing this. So you know where I'm going. Go ahead. And you say, you interrupt her and you say, I don't know if he's familiar enough with that, with the relationship between the prop master and the armorer to answer that question. But we have a witness sitting out there who may be able to answer it. If we can bring back Mr. Looper back, if you want us to. And the juror says, my biggest part of the question is, she was also responsible for procuring firearms and ammunition for a third party, not just Hannah. And then you said, understood, let me back up for a moment. And instead of asking him about procuring firearms, you say, do you have any information about the firearms training or firearm familiarity with Sarah Zachary? And you do that, but then later on, even though you say, this is not he's not familiar, I don't think he's familiar enough with this, he doesn't, you do end up asking him after, maybe 3 minutes later, do you know about whether she was responsible for procuring? And he answered it. And so my point is that you decided that she wasn't the best one. You said, we've got another witness to do this. But then we have an example here where you're saying, I don't think he's familiar enough with it, but then you let him answer the question, which you just asked the question of the juror. I can read that into the record if you want.
I just want to follow where you are so that I can
so it's
respond.
page 86. It's page 86 of Exhibit 19, and it says.
Hang on just a second. Let me catch up.
20. It's 20.
Page 20?
No, it's Exhibit 20.
Okay, I have Exhibit 20 in front of me.
Okay, and it says on page 86, you say, she's asking a question, and you say,
this is.
But okay, so you say he's. I don't think he's familiar enough. You say we can bring in somebody else. You ask her a different question from procuring. You ask about training, but then later on, you finally get to it, and you say, on page 87, line 18. And in terms of Ms. Zachary, what is your understanding of where she procured the guns? So my point is that I don't understand how you can say there was a better witness at this, so I just said there's a better witness with Hancock. And then with Rice, you say, I don't think he's familiar with it. But then you ask the question anyway. I don't understand why the grand juror couldn't ask Ms. Hancock the question and tell the grand juror herself that she couldn't answer it. Why were you telling the grand juror that she couldn't answer it?
So, first of all, in terms of what you're speaking about with regard to Mr. Rice, I would need just a moment to review that.
Okay.
If that's okay. So, because I think that's going to be pertinent to my answer. So
Absolutely.
I'm on 86, and in fact, Judge, I already have that portion highlighted. Okay, so let me kind of describe what was happening here, at least in my mind. So the initial question on 86 that is asked by the juror, the grand juror says, looking back at the alert letter, there's a notation that Sarah Zachary, the prop master for the film, was also the supervisor for Hannah Reed, but nobody's talking about her play in this. So you know where I'm going, go ahead. And I don't believe I interrupted her. And I said, I don't know if he's familiar enough with that, with the relationship between the prop master and the armorer to answer that question. And the issue that's going on in my mind is Mr. Rice, who has also never worked on a movie set, familiar with whether or not the prop master is the supervisor of the armorer when it comes to the armorer's responsibility for gun safety. So what I'm thinking in my mind at that point in time is my investigator can't answer that because he's never worked on a movie set. Then things change because the grand juror says, she clarifies her question. My biggest part of the question, if she was also responsible for procuring firearms and ammunition from a third party. When she clarified her question in that regard about where the firearms and the ammunition are coming from, and at this point, I understand she's not asking about the relationship as it pertains to who can tell the armorer what the armorer can and cannot do with guns. She clarifies the question. When she clarifies it, I realize he can answer it. He actually does know the answer to that. He knows that Sarah Zachary got the guns and she got some other ammunition from Seth Kinney. So at that point in time, I say, oh, okay, now that you've clarified your question, I mean, I didn't say it, but that's what's going on in my mind. He can go ahead and answer. So I let him go ahead and answer when she clarified it, and I understood that he did have the knowledge and experience to answer that specific question. Judge, I have to tell you, if I asked Detective Hancock right now to give us a detailed explanation of the way that safety protocols on a movie set are supposed to work, not the way they're not supposed to work, I don't believe I could get a reliable answer out of her. And while I understand the court's concerns, I want the court to understand that all I was trying to do was get the most accurate information before the grand jury. And everything that Mr. Carpenter said is absolutely accurate about the way that safety protocols on movie sets are supposed to work.
Thank you. I appreciate that. I just have one more question. So the rule on grand jury proceedings 5-302.2, it talks about instructions to the grand jury. And of course, elements and defenses is one, but the second requirement is the prosecuting attorney shall provide the grand jury with other instructions that are necessary to the fair consideration by the grand jury of the issues presented. And because it seems to me that Mr. Carpenter was provided opinion testimony, which is true. An expert can rely on that. And I know that they weren't put in as experts because it's not a trial, but you're basically indicating that you relied on him for this kind of testimony. You've got Mr. Haig in there. I'm wondering why you didn't provide that instruction to the jury so they could the credibility instruction on witness credibility or opinion testimony instructions.
It didn't occur to me. It didn't occur to me to provide that. And the defense understood the kind of testimony that we were going to elicit. It absolutely did not occur to me to give the credibility instruction. It didn't occur to me until this moment, Your Honor.
Okay. Those are all the questions I have, and thank you for being patient with me and answering them.
If you would permit me, Judge, because I have this morning had to deal with Mr. Spiro and Mr. Nickus, would you give me 60 seconds to confer with my co-counsel? I'm not going to have her address the court.
Absolutely. Yes.
Let me confer. Thank you.
Absolutely. Yes. Anything else, Ms. Morrissey?
Yeah. So I want to make clear that what we're arguing right now in terms of witness testimony, this goes to the sufficiency of the evidence. I believe, though, that their argument.
Okay, so you want to answer it as sufficiency of the evidence because Herrera was structural.
But I believe Herrera was structural because it was dealing with a jury instruction, and I believe that's proper. So in terms of when we're dealing with jury instructions, that is a structural defect. So that comes in under subsection B of the statute. In terms of sufficiency of the evidence, which is what we're talking about right now, this requires a showing of bad faith. So I agree with you that Herrera was talking about a structural defect, but that's because it went directly to a jury instruction. So in terms of witness testimony and sufficiency of the evidence, they have to demonstrate bad faith. And I think that this is clarified in State v. Yaw, that specifically indicates that challenges pursuant to 316-11B, 316-11B requires a showing of bad faith. And I'm looking at paragraph 8 of State versus Yaw.
Okay, anything else? Oh,
no,
sorry.
You're all right.
Well,
no, that's
yeah, okay. Well, I think it's
Your Honor, if I could just 60 last seconds on just some quick comments that just the things that come up. I know the court's been patient and
okay,
I appreciate it. Yeah, I just wanted to just very quickly, Ms. Morrissey started by saying, we had this plan that if this didn't all work out, we'd just dismiss the case and start over, right? If this whole, there's obviously, this is the problem with the waiver issues. There's no contemporaneous records that was actually what was going on. And you're right, it's not that big of a deal. If the court can dismiss this, if she thinks she should give this a third try, she could. But I just found that to be a remarkable comment. And of course, we've had the opportunity to talk to the witnesses and the lawyers, some of whom Ms. Morrissey was kind of recreating as she was live being questioned by you, Your Honor. And even just now, they're confirming she never contacted them. Mr. Hall's lawyer confirms never was contacted about the grand jury. Mr. Sousa's lawyer previously commented not contacted. In addition, the court should know we served a discovery request. We said any communications with any witnesses, okay? Show me one email, one internal, anything, saying, hey, we've got a grand jury in a week. The way this is supposed to work is the grand jury's in a week. There's all these witnesses that could come. You hit them with a subpoena. They come to the grand jury, or you have them on standby and you talk to them. This isn't how you're supposed to do it, period. And this is why the rest of it happens, right? And the grand jurors, they don't know what's going on. They're looking at typos. They call it a warrant letter. And the fact that there may have been a repeating of the very generic instructions that Judge Ellington was right to provide them, Judge Ellington saw it. He said, we're in the last day. They've never seen an alert letter. You have the obligation. You have the obligation. This is a homicide case. And by the way, in Ulibarri, the indictment was dismissed even though the grand jurors were presented with the generic sort of instructions. And so the final thing that I will just simply say is it was very interesting.
What am I doing? What am I doing here? Why is this guy doing
Ms. Morrissey, please don't interrupt him, okay? If you want to respond, I'll give you three minutes, but go ahead. Let me finish. Let him finish.
So, and then this was frankly the most remarkable part. The idea that it was going to be video testimony. This is what she purports to be her idea at the time, or read the police reports. You see, because she has to answer Your Honor's question. She can't answer it, so there's no good answer, right? So she says, read the police reports, which is, of course, hearsay. It's the lead detective, the lead investigator, testifying through a document as to hearsay, right? She has no choice, but she's backed into a corner. She has to say that. Then when she has to answer for the next issue, she says, no. Hancock and Rice, they can't be asked to testify about things that they learn from other people. I mean, the story doesn't work, doesn't check out, doesn't pass the laugh test. And so, of course, she cuts them off. And if you look at all the cuttings off, the 20 times, don't answer that one. No, not that one, not that one. It's always in one direction. She doesn't cut off anybody saying, I don't like Alec Baldwin. That's for sure. It's always in one direction. This is a homicide case. Prosecutors are required to do better than this. This indictment should be dismissed.
All right. And you may close, Ms. Morrissey.
I don't recall representing to this court that I reached out to Mr. Hall's attorney. I did not represent that to the court today. I specifically indicated that there was always a problem because he was represented by an attorney that was non-responsive. Mr. Souza isn't represented by a lawyer. I have no idea what Mr. Spiro is talking about. Everything that he's saying to you right now is a complete misrepresentation about what has happened. And that's what these people do. So hearsay is admissible in grand jury. Hancock and Rice, I never said that they couldn't testify about what people told them. I didn't want Hancock testifying about what people told her if it wasn't going to be responsive to the question. That is clear. I'm not going to have Hancock talk about gun safety on movie sets if all she knows is the wrong way to do it. Hearsay is admissible in grand jury. All of that was absolutely appropriate. Mr. Rice's testimony was perfectly appropriate. It was based on hearsay. This court knows very well that hearsay always comes in before the grand jury. But if I'm talking to a detective and I know that her answer is going to be based on unreliable hearsay, and that's what it was unreliable hearsay, then I'm going to stop it because I want the grand jury to get the most accurate responses to their questions. You know, Mr. Spiro wants to say to this court this morning that I'm just kind of making this up as I go along, that I had no intention of ever presenting anyone over video. I can give you the names of the DAs in the second that I spoke to prior to taking this case to grand jury to ensure that this was a practice that was normally done. And why am I speaking to DAs in the second rather than DAs in the first? Because DAs in the second deal with more complicated cases. They see more alert letters. So that's the reason that I was reaching out to them. I'm not going to sit here and be called a liar. I absolutely I did everything that I have told the court that I did today. He's right. I didn't reach out to Mr. Hall's attorney, and I didn't tell the court today that I did. So let's be clear. Mr. Spiro is intentionally trying to misrepresent and mislead this court right now. Thank you.
All right. Thank you, counsel, for your presentations. I am going to issue my ruling by order next week. I'll put it in writing. Okay.
Thank you, Your Honor.
You may look for that. Thank you very much. We are in recess.
When was the last time I took a road trip? How many national parks could I hit in 2 weeks? What about hotels? Wait, hey, Erica, how much am I spending on travel?
When your questions about life turn into questions about money, there's Erica, the virtual financial assistant to help you spend, save, and plan smarter. Only from Bank of America. What would you like the power to do? Erica is only available in the English language. You must download the latest version of the mobile banking app, only available on select mobile devices. Your chat may be recorded and monitored for quality assurance. Message and data rates and additional terms may apply. Bank of America N.A., member FDIC.